What's up, y'all? It's Cameron, this power in here and the people. We about to get into it. Sorry, I'm smoking. Yo, this one's crazy. Again, another one. Yo, this power in here and the people. You already know what it is. Yo, we get into it, man. This one's kind of crazy. Again, it's that same judge, right? The same one that I just reviewed last time with the horrible lawyer, and how when you have a horrible lawyer, horrible representation, or if you don't represent yourself, it's kind of worse than just representing yourself, right? And then in this one, what we can notice is that if we just pay attention to how attorneys are representing their defense, we can do the same thing, y'all. I don't understand what y'all don't understand. All power is inherent in you. You are the top dog. They have to rule in your favor. You top dog. You see what I'm saying? I mean, you out there, doing some causing crimes and stuff. But this is a prime example on if you can defend yourself in this type of manner while bringing up rules, principles, logic, right? Being tactful in your understanding, knowing what is right and what is wrong. Yo, you can go a long way. You can go a very long way. So let's get into it, man. Let's get into it. Let me see. I got to switch this thing real quick. How do I switch it? Okay, boom. Let's go.
That's what I'd like to revisit.
Yeah, of course. So you were on felony probation for a very serious case, evading arrest in a motor vehicle, which carries up to 10 years in prison. Now you picked up a new case. Greg, I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Zenon here. In fact, within the last 2.5 years, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case, specifically an unlawful carrying of a weapon.
It's crazy because the judge being biased right now just by like naming everything like that on the record. Like, are we here to talk about the case at hand, or like what we got going on? You
unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon.
Starting to sound biased.
Felony possession of marijuana, felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for evading, and now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay.
Pursuant to the, I guess.
I understand.
We literally had one.
See how he just did that? You see how he just pulled the judge back? So he just reined him back right there. If you watch the judge, he reined him back. He said, wait. But those were all dismissed, right, homie? Like, those were all dismissed, and then judge, pursuant to, blah, blah. But they were all dismissed. So what was the point of even naming those? What was the point of even bringing any of that up? Bias.
The other, like a rung on a step ladder. One. Yeah. So let's do probable cause.
Thank you.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate that, Your Honor.
Sure.
But be that as it may.
I'm not going to I never will hold anything against him.
Come on, man. You hear that?
So let's go.
Come on, you hear that? Oh, I'm never gonna hold anything against him, man. He totally just was all the way, 100%, man.
On December 3rd, 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed a couple at the intersection about 0.1 miles away from the HEB where the original call was located. They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant push the complainant.
So you can hear right off the bat, I'm gonna hit something for this lawyer does. You can hear right off the bat, the whole incident report sounds crazy because they show up, someone's arguing, then they pull him away and separate him from each other. He was like, man, I told her I was gonna slap her. People are all freaking out because they're all involved in being nosy. People are arguing, so they're like, oh, call the cops. Someone needs to go to jail. Bro, they just arguing. It ain't nothing crazy right now. So then the cops show up, they separate, and they talk to him. They search him. They find some marijuana on him, right?
chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon
But he has an open ag assault somewhere else too.
in Fort Bend County, Judge.
My understanding is it's
It
an
was an
older
open
case.
at that time.
Yeah,
But wait a second. What does why the judge? Why'd you get so? What does that have to do with anything right now in relation to probable cause? This is a probable cause hearing. What does that have to do with anything? I understand you're like, oh, he's got another one, but what does it have to do with the probable cause? Is putting that within by the prosecution, the state putting that within the incident report that they're bringing forth to you right now? Are they making you bias in your decision on the actual probable cause that's being brought forth by them right now, or is that to strengthen what they have because they don't have anything at all?
Judge.
May I respond to all this, Your Honor?
Sure, please.
Where's the interference? Okay.
Well, they're putting him in a car, and he's like going blank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it resisting? Maybe, but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. Like, and they're a 0.1 mile away from the location. So for what?
Well, okay, I get that, but so we have what we have. We've got a disturbance at HEB. Cops go there.
Okay.
They start to talk to him, and I guess at that point says, "Hey, man, I'm going to slap her." So at that point, I mean, that's what we have, right?
So look, both of them, both defense counsel and the defendant himself, both being like, man, that's not even what happened. They both know that's not what happened. They know there's something going on as far as they've got it all on video. So they're trying to bring it forth to get the probable cause denied and get this thrown out immediately, right? That's the whole point of what they're trying to achieve right now, is to get this case thrown away. Is there probable cause to hold dude on this false charge anymore? You see what I'm saying? Like, that's the whole point of this.
Mr. Zenon, there's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right?
And it is, he says. Right off the bat, the bias. It is. What's a terroristic threat? That I'm just going to say I'm going to slap the shit out of somebody if they take my something or throw a brick through my car? Like, you don't know what's going on, bro. Like, she could have, straight up, y'all, she could have been like, I'm gonna throw a brick through your shit. You know what I'm saying? Like, could have been for real about it. And he's like, what? You do that? I'm gonna slap the shit out of you. You know what I'm saying? So people getting heated in the moment. And when they're comfortable around each other, they gonna talk to each other like they normally talk to each other. But everybody else around is gonna be like, oh my God, it's going down. It's about to get crazy. Call the cops. They be tripping.
So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else. Was there another warrant that you said?
It's the aggravated assault. The judge. I also would like to point out that
But they end up putting him in the car. And at that point, he basically just goes blank like this, for them being unable to effectuate an arrest.
And Judge,
I think that's an interference.
I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Well, let's read the code. Let's read it, because I mean, there's no better way. Let's read it.
Hold on.
I'll give you.
Uh-oh.
All right. Let's pull up the code.
Yeah, let's get into it. Let's get into the rule of lenity. Let's get into it. I want to see. We already know, or should, if you're going through that right to travel course, if you've gone through the if you're going through the playlist right now, the advanced course on most sacred liberties to your right to locomotion, you will start to understand these aspects. Rule of lenity. We're gonna get into these.
Intake could have taken some other things, but
Well, certainly they could have taken a whole myriad of. I mean, you're lucky they didn't charge with assault of a peace officer. There's a whole host of other charges that they could have put on. You know, if
they didn't hit, they took the one that I do not believe applies here.
let's read the code. Okay. Let's see what the code says, because you know there's multiple ways.
Yeah, straight up attacking the rule of lenity on that one, right? And he just talking on right now, continue talking on about how different things can be applied, right? You can see the captions, but how different statutes can be applied, and how like you can have a misdemeanor and bump that bad boy all the way up to a felony, bro. Literally bump that bad boy all the way up to a felony, and it ain't nothing but like a misdemeanor, if that. No,
So I guess it's a person. It interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is. I agree
Okay,
with
so
that.
the cop can claim anything is interfering with public duties. I mean,
And what does that mean? If a statute is overly broad, vague, and has too much ambiguity, it must be ruled in favor of the defendant. Why? Because they have to give notice, y'all. That's the whole point of due process. You got to give notice. If there is not notice of a clear statute that has been put out there to say, hey, I can't violate that in relation to harm and crime, you see what I'm saying? On the other aspect, of course, we got statutory, regulatory law, but this isn't what that is right now. Not even close.
Truthfully, that is the vaguest thing I've ever heard of.
Judge, that's the statute. That's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
He's got bigger issues. I mean, they should have.
Now, do you see what also is cool there with that mention? It is very vague. We got to start understanding the principles of law ourselves, I feel like. At least I am. I'm understanding a little bit more the principles of law and how they can apply. If I am being a law-abiding citizen, there should be no reason for anyone to bring any charge against me whatsoever. Law-abiding citizen means bringing no harm against another. That doesn't mean falling in line with what we say is that you need to do or that you are required to do. I am required to do nothing. That is the bigger point here. I think that's what we all need to understand. We are required to do nothing. We don't got to do anything anyone says, bro. Period. In that regard, bro. Like, everybody needs to really understand that. That's the biggest thing. With knowledge, knowing if it goes against your life, liberty, or the pursuit of happiness, it's null and void. Right off the bat. That's how this country works, y'all. We are free. Administration of a free man is repugnant to his freedom. You can't get past that.
The other charge is my whole point.
Plain and clear.
I mean,
But he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1
It's an
miles
open felony
away.
warrant.
They didn't even know about the warrant. They didn't know about the warrant until.
Uh-oh. Homie said that's assuming they even had the right to detain him in the first place. Shall we go back a little bit further, Your Honor? Shall we go back and look at the initial detainment in the first place? Disruption? What do you mean? Who was causing the disruption? Because, yo, we have to get every aspect of every point before getting to did the crime occur or not. Do you understand what I'm saying? There's so much here at play that we got to start paying attention to that we can utilize ourselves when we go defend ourselves.
Sure. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay, Judge. They were investigating the assault, Judge, is what or the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like, and that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing. I mean, that's what they were investigating.
And the witnesses all described.
They put him, I guess, did they put him under arrest at the time when he said that he was making that threat?
Look at the lawyer, he quiet.
And with being.
I mean, did they have the authority to arrest at that time?
See, and she didn't answer. So the judge asked again.
Right?
So I think it was during their investigation, the defendant admitted to threatening, that he would slap Miss Clark.
Even if he admitted to saying that, bro, that's not a terroristic threat, bro. That's literally like, yo. Come on, man.
At that point, they start to put him under arrest.
At that point, they ran him through the NCIC and they found that there was an active.
And even so, if that was the case, why is that not a charge? Why is that not a charge then? You see what I'm saying? Why is that not the underlying charge then?
And then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or
Remember,
pushing. That's a resist. That's not interference
could
with
be-
public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be
Well, if it could be, then why didn't they charge it? And if they didn't charge it, you can't just go and start switching it now. That's not how this works.
with what he's trying to effectuate, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. If the officer didn't put in the report, he's not saying in the dim summary, you are under arrest.
Well, I mean, it's
Okay, well, I mean, but so
we don't know. I mean,
okay, I'm just saying.
Both he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is.
We also don't have the offense report yet,
I
Judge.
don't care. I mean, but I think that there's enough. He places him in custody.
I think that there's enough. Probable cause. He just claimed it.
He's going to arrest him, starts putting him in the car, and dude goes plank.
Again, another bias, another presumption that the dude goes plank, again, without looking at facts. If you ain't defending yourself all the way, if you ain't defending, right there I'd be like, objection. You keep saying that because I'm defending myself, that I went plank. Let's look at the actual footage itself. Let's stop all the long talk.
But I don't have the
I've shared the videos with
Remember,
you.
Right, I haven't had a chance.
guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt. You know, beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you are disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way. Like you go in there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
Okay, well, I got a second.
3 times to search me.
Can I have a moment to look at the video? Here? He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can? I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find, you know, if you find a completely set of different facts than to what they're saying on video, I'm all ears. I'm always all ears. I'm always willing to rehear probable cause at any time. I mean, it's not the be all end all. But for now, what they're telling me, if it in fact is the case, there's enough for probable cause to go forward. Is there enough beyond a reasonable doubt? I don't know. But be that as it may, you know.
All right, I'm gonna skip it over.
Okay,
to
it looks like they didn't give
the
enough
next
jargon
day.
on this.
Let's see. All right, let's get to him because the judge just starts trying to talk to, the defendant, and ain't nobody trying to hear that.
Okay, all right, Mr. Zenon. Okay, see you tomorrow.
I'm gonna agree to disagree here. But I would like for you to watch like the 2 minutes of the video that I think.
So, Judge, I also, because you had this question yesterday, I called Fort Bend and they confirmed it. The Fort Bend County aggravated assault with a deadly weapon.
And this is good too because the lawyer came right in and he straight up said, he was like, "Yo, I would like you to watch it." Like, and he firm with it too. It's like, I'm not finna waive the rights of my defendant right now, here and now. Like, y'all already had time. You made him have to come in tomorrow. I'm here now tomorrow on this. This needs to get settled. We're not going to sit here and play around with probable cause on being that it's such a low bar that just means you just get to house people and take people in like nothing. When we have actual constitutional rights, secured liberties being violated, natural rights being violated. You dig?
Just sealed, and that's why I didn't pop up.
It's just what?
It's sealed at the moment.
Sealed. Is it a new case? Is it an
It
old
was just
case?
filed in November, Judge.
Wow.
But the offense date was in March.
Okay, so that's what I'm asking. The offense date was March of 24.
Yes.
So it was allegedly committed prior to. Now, nevertheless, it's still a warrant.
It was.
But how on earth has it never been?
It's because, so they'll unseal it whenever an arrest happens, Judge. The case was filed, but he had 2 other charges in this county, even that he caught even after that one.
I'm so confused. You know that Fort Bend knows that there's a felony warrant, a dangerous felony warrant, and they failed to execute that warrant over and over. He's been on probation. He's been meeting with his.
Dude's been on probation for all this time, right? And then for a long time, and then a county comes out later after they have a sealed warrant to get him and to have him arrested after he's already on probation, rather than getting it taken care of while he wasn't.
And here that he's got on 2 years probation for, and then had also a UCW here that he caught after that, and another assault of a pregnant person that he caught here after that, and another UCW that he caught here after that. So he had just a string of cases, and I mean the list goes on. But there was just a string of cases that he caught even after that. So I guess they just never. I don't know.
I will tell you the shenanigans from my experience that Fort Bend does. So if they think they're going to TDC, I have seen them let them go to TDC, wait till they even make parole or discharge or finish that sentence, right? And then they're out and they go, "Oh, now we're going to file you." And then parole goes, "Oh, now we're going to revoke your parole." Those are the shenanigans that I've seen.
Judge,
and this has been going on for years out there. Like,
oh, so you can see, like, yo, I like this lawyer, but if people can get out here and defend themselves just like this too, or help people defend themselves just like this too, you're going to be a beast and you're going to be known. And I'm telling you right now, lawyers are going to appreciate you because they're tired of seeing it too. They're tired of seeing how poor of a state our nation is currently in. I'm telling you right now, our lawyers are like, yo, our nation's in such a poor state because we have people that just don't know anything about their rights at all. And it's just like we have to go in and, man, these courtrooms are so complacent in relation to people and lawyers working within themselves, their own courtrooms, cutting deals and stuff like that. When you have a lawyer like this come through, you know, it's like what y'all got going on in here on a 90% basis is not gonna fly with me. It's not gonna work, and you can see it. It's clear as day.
administration continue.
But I mean, I guess ultimately at the end of the day, even if that happens, like let's just say the parole board's going to look and see that was like extremely old, right? I would have the first time he
I'm not gonna read it. It doesn't matter.
Okay. As in,
I mean, it doesn't matter. It's on video. It doesn't matter.
Okay.
It's required, but
correct.
He's like, I don't even want to read the incident report or anything that y'all got to try and convince anybody that it sounds good when there's a video. Let's watch the video and see what happened instead of trying to rely. Instead of trying to rely on the video, bro.
It's on video, guys. Like, I watched it. I'm not crazy. Like, it's on video.
Sorry to keep
Let's talk to Judge about it.
You're still upset?
Yes, I watched the video and I'm even more upset, Judge.
So, Judge, we just want to address some of the questions that defense and you had yesterday. Defense was saying that he felt that interference statute was overbroad. We found case law saying that it's or vague, that it's unconstitutionally vague. We found case law saying that it's not unconstitutionally vague. It's from DeContal versus State. I tendered it to defense. Can I approach Judge?
I gotta imagine that if it was unconstitutionally vague, someone would have challenged it, and it would have,
Well, maybe I haven't had my case yet.
Okay.
And why are you saying that there's no PC in this case?
Is there PC for something else? Yes. Is there for the interference with public duties? No. I mean, because it's on video, it didn't happen, Judge. Like, so they get calls for an assault, a disturbance, whatever.
You're telling me the fact that they're saying he goes plank in the car while
he doesn't
being arrested
He does not go plank. It's on video, Judge.
Would they say he uses his? I guess he uses
He's in
his
handcuffs.
Straight up. So you see what happens? The incident report with the police officer, he done come through and wrote something. They don't want to look at the video, or the video doesn't always get there so quick, or they have it actually here. But again, the police are actually lying within the police report to make it seem as though it is something that it isn't, just to get an arrest. Like, it's like they don't care about the rights of people. It's just like, get it over with, throw them in, and then they're just done with this, like qualified immunity, when they just should be trained better. And since they're not trained better, we got to be trained better within ourselves to know exactly what we need to do within these courtrooms to not only beat the charges or claims being brought against us, but then also pursuing a pro se aspect in federal courts. I mean, there's not a lot of information, straight up on YouTube with people like that. And there are cases and audio scripts, audio of cases and stuff that you can listen to or read. But even so, like, yeah, it's kind of like time to get active and just kind of teach ourselves so that we can move forward and learn. Because the AI and everything's here. We got each other now to learn from each other. Like, it's about to get pretty cool, y'all.
To place his hand on the chest of the defendant to get the defendant to sit back in the car. He also has to grab his legs and push them back into the car. And we also watch the video.
We watched the video and we have a timestamp, Judge.
Could it be that okay, so I know that a lot of times when they're putting a defendant into the car, they need help, right? They're unable to do it by themselves, or is he actively resisting getting into the car?
He tried exiting the vehicle, Judge. And
No,
that's why they...
See, they didn't answer his question. They deflected. They didn't answer the question. They said he tried to exit the vehicle, Judge.
had to push him back into it.
He leans forward. He's yelling at his mom. Record. Call. The third time, they have taken him out. This is 3 times. They put him in the car and they take him out so they can search him. The cop is sitting there going, oh, well, search him again. We can search him 20 times. If you feel you need to search him 20 times, search him 20 times for your safety. The cop doesn't even know what he's charging him with. DA hasn't even, the cop's sitting there going, we're getting you for resisting transport. Resisting transport. That is what the cop thinks he's taking him.
What is a resisting transport? That's hilarious. But what I think, too, is something that actually is a little bit more bothersome is that, you know what, I'll wait to get to this point. I'll remember.
DA, Officer Singh, it's a 27-minute video. Okay? At no point is the DA's office called to this point. Okay? That happens after. Fine. For an assault, they can argue. I can argue case law. 4B states specific articulable facts of crime may have occurred. Fine. They are there on an assault. Okay? They didn't take an assault. So then they detain him, right? They find that he has the warrant. So, okay, you're taking him in on the warrant. Fine.
Judge, it's common for officers to conduct an investigation before they call intake. That's not an abnormal
Yeah,
process.
I mean, that's neither here nor there. But the question is he impeding the arrest or the function of arrest? Because I guess that you guys are basing the interference on the fact that he's not allowing him that, what's his name again?
Zenon, Your Honor.
Mr. Zenon is not allowing the officer to arrest him by putting him in the car.
Respectfully, Judge, the officer doesn't even have to be arresting him. They just have to be looking into any legitimate matter. And then he's interfering with that. And I will say, if he'd already been in the car 3 times, like the defense pointed out, I would think he wouldn't need help getting in. So to us, it appears as though he's trying to push out. The officer has to put his hand on his chest to push him back into the car.
These people are evil, bro. They just be straight up lying, bro. They be lying to make things fit like it's soulless, bro. It's really bad out here. I mean, this goes on all the time because, man, it is so bad out here. We got to change our country. Like, this is bad. You'll see. Watch this video.
And then take his legs and place them into the car.
He was cooperative the whole time. He's on his mom. If anyone's aggressive, it's the cop from the beginning.
Judge, the
And
cop-
I asked at the court's discretion, watch the video. You only need to watch like 2 minutes, the 13 to 15 minute mark, Your Honor. I mean, that's all you really need to watch on this.
Judge,
Watching them.
we can watch the video, Judge.
Cue it up. Let's watch.
Yeah, cue it up. Let's go.
Can you put it on the screen somehow so we can all watch?
We can just go to the back and watch it. Do you want to hook it up? I don't, because he has issues hooking his computer up to the technology. The whole video, or did you?
No, just the relevant portion. I don't need to see the whole thing.
Yeah, she don't
No,
want to.
just
Yeah, you see how the prosecutor's scrambling now. She don't want to show it on the big screen. Oh, we have problems. I don't want to show it on the big screen. No. Let's not do that.
you said it.
I'm just turning the volume up, Judge, as well.
They talking about don't let him pull up. They talking about I got a warrant out for Fort Bend County for assault. Look, he pushing me. Mama, record it. Mama, look, record him. Now you're under arrest. I'm under arrest. You charged resisting transport. Resisting? I wouldn't resist. You just resisted transport. Yep.
What the hell is that?
Now you got in your charge. Yep.
Come on.
Thank you,
These
Judge.
officers are going to take that.
Really? That's it?
That's it, Your Honor.
That's the relevant portion that defense is.
Oh, come on.
The officer is investigating legitimate.
I know, but no. All right, I'm with
You
you.
see why I'm so upset, Your Honor? Okay. Thank you.
You can refile this as resisting.
Yeah, look, yeah, I mean, you're not going to hurt our feelings. You need to do what you need to do. Perhaps it was the wrong one, but yeah, was it resisting?
Nope.
My name is Bennett, and I ain't in it. But no PC.
Thank you, Your Honor.
Get him out of here. Get him out of here. Each and every one of you have the same power to
I
do
am.
the same thing. You literally do. You literally do. Each and every single one of you have the power to do that within your own self. Just bring up the facts, y'all. We gotta start bringing up rule of lenity, all of the doctrines, every aspect of probable cause, constitutional violations. All of this gets to get brought up right off the bat, and you have to stop being in fear. And you can't let people make you feel like you should be intimidated whatsoever. If you are a good-hearted person, if you out here taking care of your family and doing what you need to do, yo, like, what? Are you kidding me? We out here trying to do the best we possibly can to educate everybody. And this goes from the very beginning to wherever that end may be. I mean, there really is no end if we get really down to it, okay? If you're really thinking. But I'm just saying. The baby courts, those administrative boys that really ain't hard no more because you got the Chevron deference repeal. That thing gone. It ain't no more. But if we talking about, the bigger ones, which Luis is doing a bigger one right now. Homeboy got a felony charge getting placed against him. But I'm pretty sure he's about to get into some conversations in relation to the rule of lenity and the aspects that, hey man, the statute is so broad and vague that it cannot apply to my situation whatsoever. And obstruction cannot apply either way because there must have been intent for me to use whatever thing that you were talking about was forgery for there to be an obstruction because the aspect that you had no reason to even come up and contact me in the first place. I think it gets so deep on all of these. And I don't know, my boy said he found something today. He got court coming up on 30th, so we're gonna see. But I think I might be able to get those motions from him too, or whatever he got going on. So we'll see. Maybe that's a tomorrow thing. I don't know. All right, well, hey, I appreciate y'all being here. Y'all check out, I got The Last Tread. That's my book I just released in November. I also got a free right to travel course. We also got the traffic law reform campaign and petition that we're about to, we're almost up to 500 signatures. We need to get that bad boy up to 1,000 so we can start sending that off to legislators and everybody across the board, representatives, committees. Then we can really get in there and talk. That's the whole business. That's where I'm really trying to be at. I'm trying to get to the point where we get the traffic law reform signed so we can push that over to our big representatives, and I mean representatives as our biggest or highest form of public service that we have within our government, right? Because when we get up and talking to them, we can really get change. Kind of like Nevada scene, you know. And I really want to start having these conversations. I think tomorrow night in our Operation Wisdom, we definitely gonna have a conversation in relation to into just what traffic law reform looks like to each and every person, their own perspective. I think that's really important. I want to know everybody's perspective. Remember, the Operation Wise Dome is free for everybody. So I think this is coming up tonight. You know, I'll run it through till tomorrow. I don't know. I guess so. Nah, I'll run it tomorrow. So, but anyways, yeah, y'all already know what's up. I appreciate y'all. We gonna get it on the next one. Peace and blessings. Remember that I am you and we are us, all a part of the great I am, and all power is inherent in you and me and we, the people. I love y'all. Y'all be good now.